So for manslaughter, no, manslaughter is not necessarily a charge. It's not usually. It can be, but it's not usually a charge. Usually, charge is murder, and manslaughter is what is resulted right after some amount of defense. So manslaughter is a criminal offense that involves the unlawful killing of another person without the element of malice aforethought, right, which is required for the charge of murder. So if you're charged with murder and they figure out that okay, malice aforethought is not met, then manslaughter will be given, right? But voluntary manslaughter. Voluntary manslaughter occurs when a defendant intentionally kills another person, but does not, but does so under circumstances that mitigate the offense from murder to manslaughter, right? So let's look at this, right? We're looking at two specific things, right? So voluntary manslaughter falls under provocation and diminished responsibility, right? So let's look at provocation. We know that provocation is a legal defense that involves the claim that the defendant's actions were influenced by sudden and intense passion or rage provoked by the victim's conduct, right? So to establish provocation, we must follow through that there was serious and sudden provocation, that the defendant acted in the heat of passion, and that there is then if successful, the defense of provocation would actually mitigate the charge of murder to voluntary manslaughter. All right. So we have that there. The important elements of provocation is always a serious provocation or heat of passion, right? There must be serious provocation known or meted out, and there must be a sudden impulse within a short period of time, a sudden impulse with a sufficient, right, a small period of time, without sufficient time, right, for reflection, right. So what we're talking about there, right. So listen to these, right. There must be grave and provocative circumstances that provoke the person. It must be powerful enough. It can't just be simple taunting. It must be powerful enough, right? And then the action, the actus reus must occur in such a short period of time that there is not enough time for reflection or a cooling off period. These are important. So let's look at where provocation all failed. RV Cracker 1989 and RV Abrams and Gregory. What occurred in these cases? So in this case of RV Cracker, right, or we could look at this, right? The husband the husband had for 11 years looked after his wife who was suffering from an incurable and incapacitating disease, right? The wife, no, she repeatedly requested him to kill her. Eventually, one of his, during one sleepless night, she continually scratched at him, keep on saying, "You promised to kill me, you bastard." Right? So she was coercing her husband to kill her. Right? Finally, the husband put a pillow over her face and asphyxiated her. He surrendered to the police and keeps saying it was her final straw. Right? He was charged with conviction of murder and appealed. Right? So there was no evidence that the husband was provoked to lose his self-control. He thought about it and he asphyxiated her. Right? Therefore, provocation failed. Right? So this is RV Cracker 1989. RV Cracker. For Abrams and Gregory now, we have something different, right? We have bullying occurring. Right? We have bullying occurring here, right? So in Abrams and Gregory, there was bullying occurring. So the deceased had bullied the accused persons over a period of time. They had not been able to secure efficient police protection. Anticipating that the deceased would have continued his usual behavior, the parties conspired with a young man to get the deceased into a drunken state, and then to encourage him to take her to his bed. Right? The accused would then come into the room and break the deceased's arms and legs. Right? The plans were duly made and executed, but the deceased died. Right? The events took place a week after the deceased's last aggression. Right? So because it took place a week after and they were anticipating this, therefore it is not provocation, and they lost, and the count was murder and not manslaughter, right? So that those um provocation failed in both Crocker and Abrams and Gregory, right? Both of these cases they failed. For Batterwoman syndrome now, Batterwoman syndrome is known as an innate partner, also known as innate partner violence, right? The victim syndrome, right? It is is a physiological condition, right? That may develop when individuals, typically women, who have been subjected to prolonged and severe domestic abuse, often at the hands of their intimate partner, right? Often at the hands of their intimate partner, right? So the battered woman syndrome is not officially recognized as a mental disorder in diagnostic manuals such as the DSM-5, right? But it is considered a valid concept in legal and physiological context. So the locus classicus, the main case here would be R.V. Duffy, 1992, right? So the appellant, right? So the appellant basically was continuously being abused, right? And I think her children as well were being abused as well by her husband, right? So the appellant attacked and killed her husband with a hammer and a hatchet whilst he was sleeping. He subjected her to violence throughout their entire marriage, and she was tired, right, of this. She was tried for murder and raised defense of provocation. She was convicted and appealed, right? So the defense failed. Let's look at the defense of provocation and how it failed. Delvin, the leading justice on the case, right, gave the classic definition of provocation. So in this case now we have the classic definition of provocation, and here we have Lord Delvin stating it, right? Provocation is some act or series of acts done or words spoken when or which would cause in any reasonable person or actually causes in the accused a sudden and temporary loss of self-control, rendering the accused so subject to passion as to make him or her for the moment not master of his or her mind, right? So it speaks to an act of provocation, right, leading to sudden and temporary loss of self-control, right, rendering the person, right, for the moment not master of his or her mind, right? So that what occurred here. So RV Duffy actually failed, right? But that's a case of Batterwoman syndrome there, right? Self-control is also used in cases, right, to propose on the proponents of Batterwoman syndrome in R versus Aloelia and in R versus Thornton, and self-defense both failed, right? So Aloelia failed, right? However, the appeal was allowed under the grounds of diminished responsibility and not um, self defense, right? And R.V. Thornton also failed. However, right, diminished responsibility was used. So we're looking at here, right? So diminished responsibility is generally the defense that we use for battered woman syndrome. If we use provocation, it's not going to work. It's gonna fail, right? So it failed in Duffy, it failed in Aloelia, it failed in Thornton. What they should have used is diminished responsibility. Alright? What we're looking at here is a reasonable man, right? This is for diminished responsibility, right? In cases where the defense of provocation is raised, courts assess whether the alleged provocation was of nature and degree that would have caused a reasonable person to lose self-control. So we're looking at whether or not the provocative instance, right, would have led to the same state of affairs that a reasonable man would have created, right? So the factors such as severity, timing, and context of provocation are considered in determining its effects, right? The role of the reasonable person standard in provocation cases is crucial in maintaining objectivity and consistency in decision making. So we don't want to apply it to a specific situation. We want to see whether or not the reasonable man would actually do this, right? Phillips v. R, which is a Jamaican case, is a very integral case as it relates to the reasonable man rather, right? So we had that there. It's an issue there. And we also have DPP versus Kaplan, right? And R versus Marshall, right? So in those two cases, DPP versus Kaplan and R versus Marshall, the courts take into consideration the sex and age of the accused, right, when determining the level of self-control to be expected. Not self-control, yeah, self-control to be expected, right? So looking at that, meaning that what could bother a 15-year-old may not bother a 45-year-old, right? What bothers males may not necessarily bother females, right? So they're taking now into consideration how provocation can change depending on the age and the sex of the individual, and those are taken into consideration in DPP versus Kaplan and R versus Marshall. All right, so those two cases are provided. Diminished responsibility under Section 5, right? We'll look at that, right? Diminished responsibility is another legal defense that may be used. What we look at for diminished responsibility is the mental impairment factors, right? So if there's a mental illness or a psychological disorder, so if there's a disease of the mind, right? If there's severe or emotional or psychological disturbances, or there's intoxication or substance abuse, we're looking at all of these different things, right? If it is successful, then the person would be guilty of manslaughter and no longer guilty of murder. So it reduces murder to manslaughter, right? And these are the rules of your incomplete defenses, right? So it is introduced due to the issues of the Manhattan rules, right? So diminished responsibility is really close to insanity, and this is because insanity, specifically for insanity to be proven, you must use the Manhattan rules. But there are some cases outside the Manhattan rules in which issues may arise, right? So we use diminished responsibility to catch all those loopholes in the Manhattan rule. The case law for diminished responsibility would be R versus Aluelia, and our locus classicus, which would be R versus Bryan. And for cases underpinning the abnormality of the mind, we use Walton v. R and R v. Tandy. All right. So I think you guys, most definitely you guys would want to know R v. Bryan and R v. Tandy. Right? Those two cases. Please know those. All right. Any questions or concerns? As it relates to voluntary manslaughter? So I gave all the cases and all the incidences in which we can reduce murder to voluntary manslaughter. What we're going to be looking at now is what happens when there's no malice of a thought now, right? Or, well, what happens when there's no malice of a thought, right? Let's look at involuntary manslaughter now. So what happens is a category of criminal homicide which involves the unlawful killing of another person, right, without intent. So voluntary manslaughter just speaks to murder without intent, right? So we have constructive manslaughter. So also known as unlawful act manslaughter, it occurs when the defendant commits an unlawful act that is likely to cause the harm or death of another. So you did not mean to hurt anybody, but your act resulted in a death, right? Actus reus, but no mens rea, right? Here we have manslaughter being devolved from it, right? So the key principles: the defendant commits an unlawful act, which can be a misdemeanor or a non-felonious felony, right? Or the unlawful act is likely to cause harm or endanger the safety of others, and the death of another person is a result of the commission of the unlawful act, right? So looking at death coming from an act, right, that without any type of malice aforethought, right? These cases are R versus Larkin, R v. Church, and death via jest or horseplay, that is in R v. Lamb, right? So hopefully me providing it with all the cases under each specific thing makes sense. Hopefully this is assisting. So you guys need to go through these cases. These are the cases for constructive manslaughter, right? They didn't mean to kill, but their state of affairs, their actus reus allowed for it to happen. Right? For example, RV Church. The appellant took the deceased into his van, right, for a sexual encounter. He was unable to satisfy her and she reproached him, slapping him in his face. They fought and he knocked her out. Unable to revive her, having made efforts to do so, the appellant threw the deceased into a river where she died from drowning. The trial judge directed the jury that if they were satisfied that the deceased was alive when she was thrown into the river, whether or not the appellant knew it, he could be found guilty for manslaughter. Question: what is the actus reus in that case there, in RV Church? I just discussed it. What is the actus reus? Because the actus reus here would have been throwing the person overboard, right? And he would have not achieved the mens rea, right, until the person has died. So they would have a coincidence there. Alright, lovely. That's RV Church. Death by jest or horseplay. So let's say that somebody's playing around and death occurred, right? That is usually meted out by RV Lamb. For gross negligence manslaughter, now we know what gross negligence speaks about, and what we'll be looking at is generally the mens rea, right, of negligence. And I know that we spoke about this before, so I don't need to go over it, right? The defendant owes a duty of care, right? And the defendant's conduct constitutes a gross breach of the duty, demonstrating the reckless disregard for the safety of others, right? And if the death of another person results from the defendant's grossly negligent conduct, right? We're looking at negligence, the 5 principles, right? The ordinary principles of the law of negligence apply in determining whether or not the defendant was in breach of the duty of care to the victim, right? Did the defendant or the duty of care to the deceased by virtue of the fact that he should have realized that if he did not take special care, some harm might result? Did the defendant breach the duty of care? Right? Did the duty of care, right? The breach in the duty of care result in the victim's death, right? So did he breach the duty of care, and did the duty of care result in the person's death? Should the defendant's breach be characterized as gross negligence? And to answer question 3 here, meaning should it be characterized, that will be dependent on the circumstances at the time of the breach occurred, right? And the jury will consider, right? The jury will consider whether or not the defendant's departure from the standard of care placed upon him involved a risk to the victim, with the result that it caused the victim's death, right? These are the general principles that we look at to determine whether or not it's gross negligence manslaughter, right? And it's generally the same principles of negligence from mens rea. The cases here is Caldwell, obviously, because Caldwell negligence, right? Caldwell, Adomarco, Stone v. Dublinson. We look at all 3 of those cases before, so those can be used. If anybody wants to separate those cases, we can also use R.V. Seymour 1983, Kong Cho Kwang versus the Queen 1985. We can use those cases. These are all case laws for gross negligence manslaughter. Alright? Reckless manslaughter now uses the same recklessness, right? So I won't even go any further. I would really use the same recklessness, right? That we know, the unjustifiable risk that results in death, right? And you can use any of the cases that we discussed before, right? That resulted in death, right? Unjustifiable risk. And we discussed a multitude of them when we were going through recklessness, alright? So that should be fine. So you guys are given cases for everything. Hopefully that is okay.